As an Ontario personal injury lawyer, I'm often asked about the part of the legal process called the examination for discovery. Injury clients ask, what is it? What isn't it? How should I prepare? What does it involve? In this video, I'm going to explain the examination for discovery process. The examination for discovery is a very important step of your lawsuit, but it doesn't have to be a frightening process. In an examination for discovery, parties and their lawyers come together to find out what an individual party, that's you, will say about their lawsuit in court. It typically takes between 2 and 7 hours, and you can take as many breaks as you need. Although it's a serious matter, it's not formal. It's held in an office, not the courtroom. The dress code is casual. All the relevant case documents are exchanged beforehand. It includes documents like medical reports, employment records, out-of-pocket expense documentation, and so on. During the examination for discovery, you will be asked straightforward questions under oath. Many of the questions will relate to the documents. Your lawyer will be next to you the entire time, protecting you from any inappropriate questions and unacceptable conduct. Here are some of the topics you will be asked about. Simple questions about yourself, like your name, where you were born, and where you live. You may be asked to go into more detail, for example, about the specific layout of your home. Questions about your employment and your education. Questions relating to the incident itself. This might be a car accident, a slip and fall, or your dispute with your insurance company. Questions about the out-of-pocket expenses you attribute to the incident or injury. Questions about your illness or injuries, like your pain levels, your treatment, and most importantly, how your life has been affected. None of the questions will be something that you cannot answer, so try not to stress about the process. If you don't remember or don't know an answer, just tell this to the opposing lawyer. Do not make anything up or guess at an answer. As your lawyer, I will meet with you ahead of time to help prepare you for the examination. Ultimately, the examination for discovery process allows the lawyers on both sides to evaluate the lawsuit. It is the first impression you will make on the other party's lawyer. They'll get an idea of what evidence they can expect at trial. They will also be able to size you up and see what kind of witness you will be. Will you be reliable and believable? Do your answers support the evidence, or do your answers contradict the evidence? As for your own lawyer, he or she will be able to evaluate the likely success of your case and advise you accordingly. The examination for discovery is usually the only time you'll have to answer questions about your lawsuit. In fact, most cases settle without ever going to trial. This is the reason why the examination for discovery process is so important and needs to be taken seriously. It's okay to be nervous, most clients are. But once the process starts, you'll find it's fairly relaxed, and the opposing lawyer is usually friendly. At my law office, my team and I guide our clients through this process to make sure it's as smooth and stress-free as it can be. If you'd like to know more about personal injury law, I encourage you to visit my website at www.injurylawyercanada.com.